The next case to come before the court is Daniel McCloud v. Jeannine Payne. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time.
Of course.
The arguments are being recorded, so please introduce yourselves, stay behind the podium, keep your voices up. You should not use the names of children or minors or victims should that arise. The judges have read your briefs. We're ready to proceed when you are. And I would just ask the appellant, would you like to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes, please.
Very well. You may proceed when you're ready.
Thank you. Good afternoon. My name is Kurt Roman, attorney for the appellant defendant Jeannine Payne. I'd like to address 3 points during my argument this morning. First, the jurisdictional issue, and I would submit that this court, Lorain County Common Police Court, did not have jurisdiction for the proceedings which were conducted here, and because of that, the case should be dismissed. If not for the jurisdictional issue, minimally, I would also submit that the case should be returned for a new trial based upon the expert issue, in that there was prejudice to the defendant about the admission of evidence concerning.
The trial court below, if I understand the briefs, they moved to have the matter sent to Cuyahoga County, and your client opposed that at the trial court.
That's
Opposed
true.
it being sent to trial. And now you're saying there's no jurisdiction. How do
That's
you
true.
bring the square those two issues?
First of all, I would say that there wasn't jurisdiction for the case to begin here in the first place. Number two.
But then you opposed and said, I'm not going to object to that.
I'm getting there.
Okay, that's fine. I apologize, I'll let you go.
That's okay. No, not a problem. It's okay. Now, what I always worry about in those kinds of instances is waiver. And my thought is, in reading this record and so forth, that if that case, that motion wasn't opposed here in this case, that could be construed as a waiver and so forth. So therefore, I would submit that that's why it was pertinent for that motion to be dismissed. And also, I think it was tactical at that point. That the case at that point in the litigation was early, and the decision was made that to be on the safe side and to be prudent, that motion to transfer should be dismissed. And finally, in addition to that, I'm not sure that there is a procedural vehicle for one case in a common pleas court to be transferred to another common pleas court. They weren't in the same case where they could be consolidated, for instance, but we were dealing with 2 courts of common pleas here, Cuyahoga County and Lorain. So it's for that reason, Your Honor, that the motion to transfer was opposed here.
Did you raise a jurisdiction or venue or anything in your answer when you filed on this case or in an motion?
In the
Lorain County case, did you move to dismiss because of lack of jurisdiction or move to have transferred because of lack of venue?
failure to state a claim upon which relief can be granted.
That's how you would view that as, okay.
I would view that as sufficiently preserving that defense, and also in addition to that, I would also add that 12G allows a litigant to raise a jurisdictional issue or challenge at any time in the litigation and so forth. So I'm well aware that there is a argument in the appellee's brief about the case was not asserted in an answer or a dispositive motion at the initiation of litigation, but in all fairness, I do believe that 12G allows that jurisdictional challenge to be raised at any time up until the time of trial. So, the third issue, probably the least important, that's why I've named it number 3, is the one about prejudgment interest. And I think under the facts of this disputed liability into the jurisdictional motion, there's an interplay of three legal principles, I think, that have to be considered in considering our position and argument. That involves Civil Rule 13A, the jurisdictional priority rule included in case law, and also the legal concept of res judicata. The verbatim language of 13A, I think, is important, and I want to read it so I don't butcher the exact language, and it indicates a pleading shall state as a counterclaim any claim which at the time of asserting the pleading, the pleader has against any opposing party. It seems pretty obvious that from the moment that this accident occurred, it was a disputed liability situation. The Cuyahoga County case was filed originally, and in that case, the passenger in the vehicle, the son of the Lorain plaintiff father, sued both drivers and so forth. So at that point, if earlier the opposition between Payne and McCloud wasn't obvious, it became obvious at that point. The pleadings in that case also continued, and McCloud had two opportunities where the bell should have rung and the light should have come on that this bodily injury claim that was tried in this court should have been raised in Cuyahoga County. And that was when McCloud cross-claimed against Payne. Number one, there's an opportunity for that personal injury claim to be raised. And more importantly than that, when Payne cross-claimed McCloud, then it was very, very obvious at that point there is a claim going from Payne to McCloud, and any type of counterclaim, be it for indemnification, contribution, or the bodily injury claim, which ended up in this building, should have been raised, because at that point there is no question that both of these parties were completely at odds with each other. The Cuyahoga County case went forward without McCloud's bodily injury claim and ended up being settled and so forth. And that's when the third legal principle intertwined with the previous two that I mentioned, and that res judicata applied, and that at that point the failure to raise the bodily injury claim in Cuyahoga County would have and should have barred the case from proceeding here in Lorain County to verdict. The reason for those three principles is really, number one, consistency. It could very well be that you have the same case that goes to trial in Cuyahoga County, comes back with one verdict for perhaps in favor of Payne, and then goes to trial here in this county, and there's a verdict in favor of McCloud. So the public, from a public policy standpoint, should have the opportunity to realize that there should be consistency in the proceedings. So the other interest, which is judicial economy, would also have been advanced if the case had been litigated to conclusion or adjudicated to conclusion, and then instead of having two cases going on about the same motor vehicle accident and so forth, consistency in judicial economy is advanced if everything's resolved in Cuyahoga County without the need to have this case proceed in Lorain County. With respect to the jurisdictional rule, let me just quote that again so I have the proper legal principle. The tribunal whose power is first invoked by the institution of proper proceedings acquiring jurisdiction to the exclusion of all other tribunals to adjudicate the entire issue and settle the rights of the parties. So, in Cuyahoga County, the essential parties to the case that eventually was tried here were already litigants in Cuyahoga County. Payne had been served in Cuyahoga County before McCloud filed his case here in Lorain County. So the issues certainly were very similar for the rule to apply, and that is we have the same drivers, we have the same litigants and the same parties in Cuyahoga County where the case could have and should have been adjudicated. I want to make sure that I have a chance to touch upon the expert
Counsel, you are at your rebuttal time now.
Okay, that's fine, Your Honor, thank you.
Thank you.
Good afternoon, may it please the court. I'm Alexander Powell. I represent the appellee, cross appellant Daniel McCloud. The Lorain County Court of Common Pleas had subject matter jurisdiction over the personal injury claims of Daniel McCloud. Subject matter jurisdiction concerns a court's power to decide a case on its merits. This was a collision that occurred in Lorain County. The only defendant in the case was Payne, who resided in Lorain County. The appellant's assignments of error should fail for three very important reasons. The first assignment of error pertaining to the subject matter jurisdiction. The first one, which to me is the most obvious, is that a defendant in a civil action does not make a counterclaim against another defendant, but he can make a cross-claim, which is permissive in nature. Now, the appellant time and time again continues to state that Mr. McCloud should have brought a counterclaim against Ms. Payne in Cuyahoga County. It's impossible and improper for a defendant to bring a counterclaim against another defendant. Any claim against another defendant is a cross-claim pursuant to the clear language of Civil Rule 13G. A pleading may state as a cross-claim any claim made by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein relating to the subject matter of the original action. Daniel McCloud in the Cuyahoga County case was a defendant, just as Payne was. The plain language of the Civil Rule 13G states that a cross-claim may be brought. It does not require it, just like a compulsory counterclaim does. Cross-claims, the Ohio Supreme Court has held in Huntington National Bank versus Ross that cross-claims, claims by one party against a co-party arising out of the same transaction that is the subject matter of the original action or counterclaim are not compulsory or mandatory. The Ninth District Court of Appeals has also followed this in McCleese versus Bierman, where they held that a failure to file a cross-claim does not bar a direct action. In Sedlak versus City of Solon, the 10th District Court of Appeals stated that the civil rules do not provide for the assertion of counterclaims against co-parties, and that a cross-claim is the only method by which co-defendants can assert claims against each other in the original action.
Counsel, can you speak to the issue of Civil Rule 13A and what it provides for, as well as Reading, the Supreme Court case, Reading Enterprises v. Kohler?
So 13A, I believe, is the compulsory counterclaim. So this is not a counterclaim. In the Cuyahoga County case, the plaintiff was David McCloud, not Daniel, and the defendants were several people. The defendants were my client, Daniel McCloud, Ms. Payne, a third party, Mr. Klotchke, and Cincinnati Insurance Company. So, 13A does not apply in this case because it's not a compulsory counterclaim. Ms. Payne was not making a claim against Daniel, and Daniel was not making a claim against Ms. Payne in that case when it was first filed. So I don't think that 13A is the correct statute that we should be, or the correct rule that we're looking at is 13G, because this was not a compulsory counterclaim, but a permissive cross-claim. Now, the second reason that the jurisdictional argument fails in this case. And while I maintain the position that Mr. McCloud was well within his right pursuant to 13G to file and continue his action in Lorain County, is because at the beginning of the case, Mr. McCloud attempted to transfer the Lorain County case to Cuyahoga County in an attempt to streamline things. And Ms. Payne came out and vehemently opposed the motion to transfer and consolidate back over to Cuyahoga County. That act screams for the application of the invited error doctrine. In fact, in the brief in opposition that Payne filed when I filed the motion to transfer over to Cuyahoga County, she argued that Cuyahoga County case should be transferred and the case consolidated into this case in Lorain County. So, but now in the appeal, the appellant is arguing that there's no procedural mechanism for Lorain to be able to transfer a case over to Cuyahoga, but in that same motion saying that, well, Cuyahoga should transfer over to Lorain. And Payne vehemently argued in that motion that the proper county that this case should remain in is Lorain County, and that the two cases should remain separate. Those are the words that Payne used in her brief. I would just like to argue and say that what kind of message would it send to litigants if a party is able to do this type of thing? Consider the public policy ramifications that we would be setting to permit a party to fight to keep a case in Lorain County, and then when the court agrees with that party, to do a 180 turn and say, ha-ha, Lorain County wasn't the proper case, even though we fought and said that Lorain County was the only proper county for this lawsuit. Not to mention then, doing this after spending 3 years litigating here in Lorain County and incurring thousands of dollars of case expenses and doing deposition after deposition. This case is the poster child for the invited error doctrine. To address the jurisdictional priority rule argument made by counsel, generally, it is a condition of the operation of the state jurisdictional priority rule that claims or causes of action be the same in both cases, and if the second case is not for the same cause of action, nor between the same parties, then the former suit will not prevent the latter. It's undisputed that in this case, the parties in Cuyahoga County were not the same parties as the case here in Lorain County. The parties were David McCloud, and then the people that I said later, Cincinnati Insurance Company, Brian Klotchke, and Mr. McCloud and Payne. So the parties were different, and the causes of action were different. The causes of action in Cuyahoga County were David McCloud's causes of action for his injuries versus for two different accidents, this accident and then another subsequent accident that happened in Cuyahoga County. So as such, it cannot be said that the second case in Lorain County was for the same causes of action and between the same parties, and therefore the arguments about invoking the jurisdictional priority rule should not be well taken. And I filed a notice of supplemental authority yesterday evening because I had missed a case in my brief. But the 9th District Court of Appeals pretty recently in 2020 has held in State Ex Rel Gubriel versus Summit County Court of Common Pleas that when invoking the jurisdictional priority rule, the parties and the causes of action must be the same. The trial court in its February 8th, 2022 judgment entry denying appellant's renewed motion to dismiss cogently explained why the court had subject matter here in Lorain County. The court stated, given the timing of the filing and service of this action and the diversity of the parties between this case and Cuyahoga County case, this court finds that it both had subject matter jurisdiction and venue in this case. That the jurisdictional priority rule is inapplicable herein, and that the defendant has waived the affirmative defenses of res judicata, improper venue, and that plaintiff's claims were not compulsory in the Cuyahoga County case. One thing I'd like to correct what counsel argued in the briefing here today is that in Cuyahoga County, that service was not completed yet on Ms. Payne because the original complaint was filed, but then before service, an amended complaint was filed. the plaintiff filed an amended complaint to add another party. And at that time, service had not been, when the Lorain County case was filed, service of that amended complaint had not been made in Cuyahoga County. So this matter was filed prior to service being obtained in Cuyahoga County on Ms. Payne. So this case was in fact initiated prior to service and the jurisdiction of Cuyahoga County, Cuyahoga County having jurisdiction on Ms. Payne and Mr. McCloud. I'd like to address assignment error number 2 pertaining to the expert issue. Assignment of error 2 should be overruled. Payne has not shown that the trial court abused its discretion when it permitted the plaintiff's treating surgeon to give opinions that the plaintiff sustained an aggravation of the pre-existing arthritis in his neck as a result of this accident. I think everyone will admit, the trial court admitted that this was a shoulder injury case. The major injury was a rotator cuff that needed surgery. And in addition to that, the treating doctor, Dr. Zanotti, who testified in this case, he authored, he had medical records which were provided to counsel in a timely fashion pursuant to Civil Rule 26B7, which contained in every single visit mentions of the neck pain, neck injury, aggravation of arthritis, limitations. So to argue that they were surprised or trial by ambush that the neck was also related to this accident, you know, the trial court did not find that a valid argument. It was not, the plaintiff did obtain an expert report from Dr. Zanotti, and that was done after the defendant obtained an expert report, an untimely expert report from a defense doctor who stated that, you know, the shoulder was not related. So not only was the formal expert report provided, which discussed the shoulder, but also the medical records, which discussed the neck and the shoulder, were provided to counsel well before trial. As further evidence that there was no abuse of discretion by the trial court in allowing Dr. Zanotti to testify about the neck aggravation is that the trial court actually struck all testimony about permanency and permanency involving the neck. And the court made that decision, used its discretion to make that decision because, you know, when you provide medical records, the medical records normally don't discuss opinions about permanency. So because those medical records didn't say, I find that Mr. McCloud has a permanent neck injury, any testimony pertaining to opinions of permanency was stricken from the record. So that's just another way to show you that there was no abuse of discretion here. The trial court ended up striking a large amount of testimony pertaining to permanency here and did not permit the plaintiff to ask the jury for future damages because of a lack of permanency. I'd like to discuss very briefly the appellant's assignments of error 3. I'm not going to argue that because they failed to argue it in their brief pertaining to the motion for a new trial. Assignment of error 4 of the appellant involves the granting of costs. Very briefly, I'll just say that there was no evidence that the trial court abused its discretion in awarding, you know, $937.80 in costs. In fact, while it's the position that the court should have granted all the costs that we requested with all the transcripts of the experts and things, you know, we understand that the trial court used its inherent discretion in that. How much time do I have, Your Honor?
You have 3 minutes and 20 seconds.
Thank you. I'm going to address now the cross appeal. The cross appeal involves 3 assignments of error. The first 2 have to do with the trial court denying my client's right to get the claims file from State Farm to conduct any discovery whatsoever for our motion for prejudgment interest. The plaintiff filed a subpoena against State Farm to get the claims file so we could learn who was involved and start doing depositions, and the trial court barred the plaintiff from doing any discovery whatsoever on the motion for prejudgment interest. The only person that filed the motion to quash was Payne's attorney. State Farm never filed a motion to quash.
But before we get to that, I mean, it seems to me the judge may have been just saying this is not a prejudgment interest case, period. We don't need to get into all the discovery because there were facts alleged in this case by Ms. Payne that your client came out of the driveway and that was negligent in that regard, and I think in fact the jury found her negligent. They had some accident reconstructionists, and they had a good faith defense of what they were doing, so they had the right to make that claim, and therefore we don't get into prejudgment interest. So we even have to reach that issue if we find that the court correctly determined this was not a prejudgment interest case.
Well, I think that it's a separate issue because it's an issue as to whether a party is permitted to conduct discovery on the issue of prejudgment interest and to get that claims filed. There are some issues in this case as to whether truly this was a disputed liability accident because the tortfeasor paid the full property damage. They paid for the entire car as there was no dispute in liability, but then when it comes to the injuries, dug their heels.
That doesn't necessarily mean there's no dispute in liability. It means they're just willing to settle the claim for that amount of money. They may still dispute liability, but I think I recall from the brief this wasn't a high damage vehicle, and their perspective, we just paid it off because we were going to continue to dispute liability on the actual personal injury, which was a much higher claim.
Yeah, and that was the State Farm's argument in this case, but I still feel that essentially barring a party from being able to present any actual evidence at a prejudgment interest hearing was error and an abuse of discretion, because we weren't able to get any type of evidence it's supposed to be an evidentiary hearing, and we were obstructed from doing that based on the court's ruling. And my final assignment of error is that the court should have granted prejudgment interest. I briefed, the various, I think I'm out of time, so I briefed the various prongs of Kalin, and I feel that a good faith offer wasn't made in this case. When the jury awarded $100,000, the final offer was only $30,000, plus all the issues with delaying the proceedings and all that kind of thing. But in closing, I respectfully request that the court overrule all 4 assignments of error of the appellant and affirm the jury's verdict in favor of the appellee, because the court did have jurisdiction in this case. And for the cross appeal, we ask that the court either reverse or remand the case back to the trial court for the order to produce the State Farm's claims file so that we can do discovery, do depositions, or in the alternative, grant prejudgment interest for the plaintiff. Thank you very much.
Thank you, counsel. You will have 4 minutes and 55 seconds.
Thank you, Your Honor. Whether the particular claim is a counterclaim or a cross-claim is semantics. In general, a counterclaim versus a cross-claim are 2 different things. I understand that. But in the context of this case, counterclaim versus cross-claim is semantics. And that's because 13A, as I quoted before, says any claim where the parties become adverse as they were inherently in this case. I don't think it's a good idea for any practitioner when faced with this procedural situation with a claim being made directly against McCloud to ignore the provisions of Rule 13A. It may be a situation where there's a difference between a cross-claim or a counterclaim, but if you're looking for the interests that are to be advanced by the jurisdictional priority rule, that is consistency in judicial economy by ignoring those provisions and not asserting the bodily injury claim in Cuyahoga County. I submit if there was any invited error in this case, it was caused by McCloud when he didn't assert the bodily injury claim, when he had at least 2 procedural reasons for him to do so in Cuyahoga County. With respect to the Cuyahoga case having a second accident, it had absolutely nothing to do with the parties in this courthouse, the plaintiff and the defendant. This second accident was a second accident that the passenger's son was involved in, not the plaintiff father in Lorain County. So what Cincinnati Insurance Company, who was, by the way, dismissed very early on in that litigation, or a second accident might have to do with the son's claim, it's not going to have any effect on a jury litigating both the liability issues and damages issues between Payne and the father, Daniel McCloud. These supplemental authorities, which I was a little disappointed to receive at 10 o'clock, damage Payne's position on the jurisdictional priority issue. Those two cases are very readily distinguishable from this case. The first one was Sandusky, Erie County case, I believe, where the issues in the two competing claims were about a zoning issue, and then whether I believe it was a zoning issue could be on the ballot. In this case, there was consistency or relatedness with McCloud and Payne because it was the same accident, the same issues, liability and damages that had to be decided from one accident in the same parties. The Gubrial case out of Summit County is even much more distinguishable. If you read that case, the two potential pieces of litigation involved a divorce, and all the other things that were going on with Dr. Gubrial and K&R regarding fraud and those kinds of things, which have been litigated for years and years. So the two pieces of litigation in those two cases aren't anything like the similarity that we had here, where you had the same parties in the same accident, which should have been combined in Cuyahoga County. The issue on service, I mean, I looked at the court docket. McCloud and Payne were both served on 3/12/19 in Cuyahoga County. McCloud didn't file here till a week later in March of 19. Now, there was an amended complaint filed in Cuyahoga County, that's true, but that's when Cincinnati Insurance Company in the second accident were joined in the amended complaint. If a defendant is served in the original complaint and new party defendants are added that have nothing to do with the original defendant, some people don't even think you have to file an answer, but
Are these issues with the docket in Cuyahoga County, are they somehow on the record before us? And one of the motions to transfer anything, were those dockets filed in this case, or you folks just telling us, hey, we looked the docket and it says that?
I am almost positive that those dockets are attached as an exhibit to one or more motions that are part of the record in this case. So,
And counsel, I'm going to have to ask you to wrap up.
okay. Barely had a chance to talk about the neck. Let me just say this. It's true that there were numerous complaints about the neck in those records, but to me, that's more favorable to the defendant
Okay,
because...
counsel, I'm going to have to ask you to.
Okay, fair enough. Thank you for your time and consideration.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk, of course, will mail a copy of that decision to you on the day that it is